come in, but let's begin. Good evening, everyone, or good afternoon if you're watching in North America on Zoom. My name is Paul Gross. I'm a senior fellow here at the Menachem Heritage Center, and it's a pleasure to welcome you either in person or virtually to the latest in our series, regular series of events for English speakers. Obviously, since October 7th, these events have taken on a very, tended to take on a very contemporary feel. We've been dealing with topics as and when they occur, and it's always a pleasure to be able to invite guest speakers, especially from abroad, who are visiting, as today, who are playing a very particular role, I think, in the current struggle that we are all in our different ways involved in. I think many of us would agree that following what's going on here in Israel and also around the world with Jewish communities can be quite grueling, quite depressing at times. And I think one of the few sort of pleasures that I get following this news is when I see one of Israel's many critics and delegitimizers really taken to task. So I don't know if people here saw our speaker Natasha in the month debate recently alongside Douglas Murray against Mehdi Hasan and Gideon Levy. If you haven't, you really must Google it, YouTube it, either the whole thing or at least watch Natasha's contributions. In particular, where Mehdi Hasan quotes Balfour in a way which implies that Balfour is a raging anti-Semite, and then Natasha promptly reveals that he very selectively quoted Balfour, and the actual entire quote gives a very different picture, and it reveals and completely discredits Mehdi Hasan. I particularly enjoyed it because he's one of the people that particularly gets my goat. So just on a personal note. But anyway, before we begin, I'll just say how this is going to work. I'm going to introduce our speaker. We're going to have a conversation, she and I, for about half an hour or so, and then we'll of course invite questions from the audience here. Okay, so Natasha Hausdorff is someone who many of you would have seen on television or on social media or on YouTube. She's a barrister from the UK, an expert commentator on international law, including the law of armed conflict, foreign affairs, and national security policy. She holds law degrees from Oxford and Tel Aviv University, and was a fellow in the National Security Law Program at Columbia Law School in New York. Natasha previously worked for the American law firm Skadden Arps in London and Brussels, and clerked for the President of the Israeli Supreme Court, Chief Justice Miriam Naor, here in Jerusalem, and she currently serves as legal director of UK Lawyers for Israel Charitable Trust. Without further ado, Natasha Hausdorff.
Okay. Yes, everyone can hear me, I think. All right. Natasha, thank you so much for joining us.
It's really my pleasure to be here, and thank you for that wonderful introduction.
Pleasure. Before I get to the meat of it, I do have to ask, how do you know that Mehdi Hasan was gonna, or did you know the Balfour quote, and so you just looked it up quickly while he was, I was watching thinking, how did she do that? That was brilliant.
I'm actually especially pleased that you brought this up this evening, because I think the first message I want to leave everyone with is, it takes a village. And I am particularly grateful to Sean Sachs, who is in the audience, because the issue of the Balfour quote, or misquote as it happens, came about from a conversation I had with Sean in advance of the debate. And it was because Mehdi had deployed exactly the same quote in a debate against another member of the audience, Melanie Phillips, where she was appearing alongside Einat Wilf. And albeit there are many, many falsehoods that have been uttered by this particular individual, the ability to, I suppose, pull him up on that particular one in real time, I attribute entirely to the efforts both of Melanie and of Sean. And to be in a position to do that in the context of the Montaigne in Toronto was something I felt extremely privileged to do, but I could certainly never have done it alone.
Fantastic. Thank you, Melanie. Thank you, Sean. Round of applause. Okay. So we're going to be discussing, amongst other things, lawfare. As you're British, because I'm speaking to a fellow Brit, it's a word which works much better in British, because with a British accent, law rhymes with war. In American accent, it doesn't work as well. So can you just, for our audience's benefit, just give a brief definition of what lawfare is and why it's so pertinent to the Israeli conversation?
I can give you my definition, and I appreciate that others have and will continue to interpret lawfare differently. But I consider lawfare to be an abuse of legal processes, legal institutions, an abuse of those institutions for a political purpose, in pursuit of a potential political agenda. The Lawfare blog has certainly used this term differently. The Lawfare project absolutely has used this term differently. But I would distinguish lawfare as a negative phenomenon from the proper application of law. And when we look at lawfare in an international context, it's a lot more palpable, I think significant, because the international legal system is inevitably influenced by politics to a far greater extent than our national legal systems, our domestic legal systems. And it's so much more open to abuse. And we have seen recent examples, I know we'll come on to discuss them, at the ICC and at the ICJ, where lawfare is targeting Israel. I would highlight an article that I recall reading by Mahmoud Abbas in 2011, when there was a great debate about the potential for Palestine to join the United Nations. Abbas wrote about his desire to see the internationalization of the conflict as a legal, not just a political matter. I read that at the time and today as Mahmoud Abbas's declaration of lawfare against the State of Israel. And since that time, we have seen that practice, that abuse of international legal order, be put into practice against Israel at international legal institutions, at the UN, by many UN bodies, even by UN experts, special rapporteurs, and in many respects it has involved something I also referenced at the Monk debates, the modern blood libels against the State of Israel, which, interestingly enough, form or fall often in the context of legal terminology, legal accusations, occupation, ethnic cleansing, colonialism, apartheid, genocide, all underpinned by legal frameworks, but all, I would suggest, deeply misrepresentative, abuses of those terms for a political purpose, but extremely effective because the general levels of literacy, especially about international law, are relatively low. And if you tell the average person in the street that Israel is violating international humanitarian law, or Israel is committing war crimes, or other breaches of public international law, then their ability to conduct a critical assessment of that is extremely limited. And more often than not, they're going to take your word for it.
Right. It's like the whole proportionality concept, right? Where it's used all the time by news anchors, by interviewers, and it's just sort of seems to be assumed to mean one protagonist does exactly the same, or some sort of like equivalent action to what they suffered. And proportionality in international law doesn't mean that at all. And as you have very eloquently explained.
It's interesting to me that Douglas has called out the same, Douglas Murray has called out the same preposterous suggestion that there needs to be some sort of equivalence of action on both sides. And he has said that as a result, proportionality itself is just a ridiculous concept. And that's very interesting to me because it's attacking the falsehood from a non-legal perspective. in actuality, the principle of proportionality does exist in international law. It's just not at all the way it's understood, it seems, in international discourse, or certainly in the media. It's macabre to suggest that you need to do a casualty count on both sides and have a sort of score drawn. It would also, of course, serve to encourage Hamas to continue their policy of using civilians as human shields to drive up the casualty count as much as possible. And it's flatly not how proportionality works in international law. It's definitely more nuanced and complex. The principle of proportionality requires each individual military commander to conduct a balancing exercise, to weigh up the anticipated military advantage of each strike, an advantage that is direct and concrete, and that is militarily necessary to advance the aims of a conflict, to weigh that up against the expected civilian damage, the collateral damage, which is often referred to. And there's no magic formula for that. It's based on practice, it's based on operational assessments. This is something that Israel has spent a great deal of time through the Military Advocate General Corps, the lawyers in the IDF, fine-tuning, and the assessments by other modern law-abiding militaries, in particular the United States and the United Kingdom, is consistently that Israel sets standards, including on proportionality, that are unparalleled in the history of warfare, that other modern law-abiding armies would struggle to meet in the contexts and the challenges that Israel faces when we consider the urban armed conflict scenario that John Spencer has described in great detail that Israel has encountered in the Gaza Strip, where Hamas has spent 16 years embedding itself in civilian infrastructure, schools, hospitals, mosques, where every second house is being used as part of that terror infrastructure, and where human shields are an integral part of Hamas's strategy. The proportionality analysis that Israel conducts in those contexts is, the experts tell us, second to none. And in many respects that's also reflected in the casualty ratios. The one that we are given to understand that is most reflective of more accurate numbers, so not the numbers that Hamas is putting out as part of their propaganda machine that are being quoted without qualification often by the international media. The assessment of the government of Israel has been that the casualty ratio is more likely in the region of 1-to-1. Now, 1-to-1 is unprecedented in the history of urban armed conflict. The average ratio put out by the United Nations is a very disturbing 9-to-1, 9 civilians to every 1 combatant. In Iraq, in Afghanistan, the United States health authorities put out statistics that indicated the ratios there were 3-to-1 and 5-to-1. 1-to-1 is pretty extraordinary. But I say that with a qualification because the principle of proportionality is not an effects-based analysis. If Israel conducts a strike, believing that it has conducted a proportionality analysis and there will be very few civilians who are killed as a result, and for some reason, because of intelligence that it didn't have, because there were more civilians in the vicinity than it could have appreciated, the proportionality ratio is of a different order, that doesn't render that strike in any way unlawful. The law of armed conflict requires an intention-based analysis, not an effects-based analysis. And so by every measure, the proportionality of Israel's conduct has been beyond that which many experts in the field are saying that other armies would be able to compete with.
Right, and I think it's indicative of the general principle that we're all aware of the double standards towards Israel, that this whole conversation only takes place around Israel. There's no other conflict, there's no other party to conflict that is forced to even defend itself against these kinds of accusations that it's not taking enough care about civilian casualties, that it needs to explain what proportionality is, because that whole conversation doesn't happen in any other context. It's a very good example of, I think, of the double standard. You mentioned John Spencer. I commend him if he hasn't read him. He's, I think, a West Point urban warfare expert at West Point, and he's made the case, as you said, that even the American forces fighting in Mosul didn't have to deal with what Israel's dealing with, which is this embedded, as you say, the tunnel network, the larger than the New York subway system or the London Underground, and ISIS had been there for I think less than a year when the Americans invaded, whereas Hamas have had whatever it is, 17 years, whatever it is, to embed themselves.
These two issues are entirely interlinked.
Right.
Because creating civilian casualties is devastatingly the core mission that Hamas is operating according to. If we step back for a moment, they cannot hope to win against Israel. Their greatest achievement was the 7th of October. Their only aim operationally at this juncture is to survive. And their means of achieving that is by driving up international pressure, exactly the way that you have described, through increasing the civilian casualty count. And that is why I believe we've also seen reports when Israel was creating humanitarian corridors, encouraging civilians to evacuate, of Hamas shooting fleeing civilians, bombing civilian convoys that were seeking to adhere to the evacuation advice. And in that context, and this is something that the international media unfortunately do not focus on, the abuses of the Palestinians in Gaza by Hamas and by Palestinian Islamic Jihad. Because, as you I think correctly identified, that narrative is very much focused, honed in on Israel. But when you consider the scrutiny that the IDF is under, it stands to reason that there's also an encouragement to take greater precautions, and I think we've also seen that every single conflict from 2008 to today. Israel has been improving its approaches, has been improving its accuracy, precision-guided munitions, policies and tactics like knock-on roof, giving warnings. No other army has taken the kind of measures that Israel has to send text messages to individual households, phone calls, leaflets, guarding humanitarian corridors. I mean, there are a number of soldiers who have given their own reports of being fired upon by Hamas while defending civilian convoys who were evacuating. But those are, of course, not the stories that are reported in the international press.
Needless to say. Yeah, I mean, there was a good example actually from the country we're both from, of how this, how far this whole question of the misrepresentation can go. With there's a member of the Scottish Parliament, I think, who was suspended from. Remember, a Scottish National Party member of the Scottish Parliament was suspended by the party for tweeting that Israel is not guilty of genocide.
I'm actually not aware.
So yeah, I forget his name. Maybe some Mason. Thank you, man. He basically, he, as far as I'm aware, is the first case of a British politician being suspended by the party for simply stating a fact. But he basically said that Israel it's clearly not. I think he said something like, if they wanted to commit genocide, then they would have killed far more people than they had. So it was a sort of general statement.
It's the only country accused of committing genocide where the people that accusation is made in respect of have been increasing in over that entire.
The world's least effective genocide, yes. Right, so I want to get to something you mentioned at the beginning, which is where this whole lawfare question gets really weaponized by institutions, which is the ICC, the International Criminal Court, and the ICJ, the International Court of Justice. Firstly, for the layperson, including me, could you distinguish between those two and the role they are both playing in the current conflict?
The International Court of Justice is the highest court of the United Nations, and its primary purpose is to deal with issues, resolve disputes between states. States have legal personality in international law. International law is all about how states mostly interact with each other. So any dispute between two states that consent essentially to have that dispute resolved by the International Court of Justice, that court has the ability to give a binding ruling. The other purpose that the court serves is to provide what's called an advisory opinion. These are non-binding, but it's advice. in the recent case with respect to Israel, it is advice that was sought by the General Assembly in a resolution passed not by a very significant majority, and mostly by, I think, 2/3 of the states voting in favour of it either don't recognise Israel or have no diplomatic relations with it. So they can be politically motivated questions, but the court is supposed to opine, give its opinion on the legal questions that are put to it. So those are the sort of two parallel tracks that exist in the International Court of Justice. One binding, if one state brings a claim, an allegation, a dispute to the court against another state, and one non-binding, which is in an advisory capacity. The other court that sits in The Hague is the International Criminal Court, relevant to our conversation. That deals with individuals, and it deals with individual criminal responsibility. But that jurisdiction of that court is essentially based on the jurisdiction that the states who have signed up to the International Court, the International Criminal Court, give to the court. So the court was established by something called the Rome Statute. It's the treaty that has not only established the court, but also set out its competence, the jurisdiction that the court has. I would suggest that it was pretty clear early on that the International Criminal Court was going to be weaponized against the Jewish state. And I say that because even at the drafting of the Rome Statute, there was a strong indication that Israel was going to be targeted. We see this when we look at Article 8 of the Rome Statute, which lists war crimes, and it includes the crime of transfer of populations into occupied territory. That crime has been taken, the concept of it has been taken from the Fourth Geneva Convention, Article 49.6. But when it was transposed into the Rome Statute, there were some additional words that were included, directly or indirectly. Now this is very interesting because the provision under Article 49.6 that prohibits the transfer of populations into occupied territory, that was drafted in response to the practice of the Nazis that did forcibly transfer populations. Ironically, one might think, it was the Jewish victims of the Shoah that were targeted in this fashion, that were the victims of this sort of transfer to concentration camps, to slave labor camps for extermination. So in the aftermath of the Holocaust, the drafting of the Fourth Geneva Convention included this practice. But when it was transposed into the Rome Statute, I think it's pretty clear that it was intended to criminalize the presence of Jews in Judea and Samaria. Directly or indirectly changes entirely the notion of a state actively transferring people, as the Nazis did. And you frequently now, in the context of the debate, and hopefully we'll come on to it in more detail, with respect to settlements, you frequently hear people saying, but of course now things have developed further with respect to directly or indirectly, and that includes individuals moving to Judea and Samaria as an expression of their own free will, of their own volition, not as a result of state transfer. And I think that's a key reason that neither the US nor Israel joined the Rome Statute, joined the International Criminal Court. And that is, we're getting a little bit ahead of ourselves, but it's important that I explain, with respect to the ICC, it has no jurisdiction over Israeli territory. The territorial jurisdiction that is delegated to the court by members of the court doesn't exist because Israel hasn't joined, but it also can't. It's not possible for the Palestinians to delegate to the court something they do not have. And the Oslo Accords were explicit that the Palestinian Authority, the Palestinian leadership, was not going to have any criminal jurisdiction over Israelis. And yet, what we have seen in the context of the investigation that was begun at the ICC, in the context of now this recent application for arrest warrants, is a very troubling twisting, both of the very fundamental issues of jurisdiction that the court is established with and ultimately gives it the competence to act, but also of these critical international agreements that had widespread support and endorsement, even from the United Nations, that are being ridden over roughshod in order, again, I would suggest, to rehabilitate a court that has seen immense criticism. There have been reports into why the International Criminal Court has been such a failure, its track record of successful prosecutions, its focus on only African defendants is a matter of great concern to anyone that hoped that the International Criminal Court would serve as a bastion of international criminal justice. And I think what we're currently seeing in the legal acrobatics that have been engaged in, both by the previous prosecutor, Fatou Bensouda, and the current prosecutor, Karim Khan, is an attempt to rehabilitate this failed international legal institution by going after the world's punching bag, the only juris state.
Right, I was going to say there's no better target for it. Israel is the best target for it. It's almost guaranteed to get support from various quarters, from significant quarters of the world. Let's go on to something you touched on there, which is the much bigger and long-standing question of international law around the establishment of the State of Israel, the borders of the State of Israel. And I know that you've spoken and written previously very compellingly about how international law determines the borders of newly emerging states, and how that is just not understood by the vast majority of people that tend to talk about the legitimacy or otherwise of Israel's, of either Judea and Samaria or even Israel itself. Can you speak to that?
I think the strange thing is that this rule of customary international law is understood in what seems to be every single context except Israel's. And of all of the debates and conversations that I've had in probably a decade, including with international law academics, I have not had one single individual explain to me the reason for disapplying what is a universal rule of customary international law in Israel's case. Now, customary international law is not contained in treaties. It is something that develops over time. But this rule, uti possidetis juris, was held by the International Court of Justice to have been established in the Burkina Faso Mali case in the 1980s. The court traced the establishment of this principle, the development of this rule. It talked about its emergence in the 19th century in South America with the withdrawal of the Spanish. The essence of this rule is to prevent there being a vacuum when a colonial power leaves a territory, the prevention of there being what was called, in that context, a terra nullius, a kind of no man's land. It was applied in Asia, it was applied in Africa, it was applied in the dissolution also of the communist federations, and to all of the states that emerged from mandates, because Israel was not the only one, mandate from Mesopotamia, from the Kingdom of Iraq, the Transjordan mandate, when it became the Hashemite Kingdom. In all of those contexts, this rule was applied. And when the court talked about its evolution, it also talked about the reasons for its development, to provide clean lines, stability, certainty, to prevent fratricidal struggles.
And just to clarify, this rule says that
That was a long introduction.
The borders are effectively the same borders that existed under the previous administration, is that right?
So in a desire to provide that stability and certainty, it simply says, what was there before continues. So any administrative lines that the new state emerges into automatically become its internationally recognised borders. Now, where you have a larger entity with many states breaking out from it, for example, Yugoslavia, then it's those individual administrative units that become the new states. And those those administrative lines become the internationally recognised borders. When we're looking at Israel's emergence in 1948, and the court talks about the application of this rule at the critical date of independence, it talks about taking a snapshot, a photograph of the territory, at the Declaration of Independence to determine what those administrative lines are. Well, at At Israel's creation, Transjordan had already been severed by the British from the Mandate, but the administrative line that had divided that part of the Mandate territory ran down along the Jordan River to the Red Sea. And when Israel came into existence as the only state to declare independence, as the only state to emerge at the withdrawal of the British on the 14th of May 1948, this default rule of customary international law dictates that Israel inherited the pre-existing administrative lines as its internationally recognized borders, and so the territory within that, as a starting point, has to be Israeli sovereign territory. That's not an argument for what the future of the territory should be or what any political resolution should look like. This is an argument for applying international law equally, for being clear about what the origins of the status of the territory are, because that necessarily has implications for any kind of legal analysis that you are going to conduct after that. And I appreciate, I don't want to switch all the non-lawyers in the room off. The reason I'm saying that the legal analysis is critical is because all of the blood libels that I listed earlier are based on a misrepresentation of the legal status of the territory. Now, as lawyers, we deal in rules and case studies. You cannot have a general rule and an exception for a country you don't like very much, and you have some political or ideological opposition to. That's not how any respectable legal system can operate. So we take the rule and we apply it to different factual situations. I think there's a very important parallel situation, which is generally well known now because of the war that Russia has launched against Ukraine. Russia occupied Crimea from Ukraine, and there is a general international consensus that that is the case. Ukraine's borders followed uti possidetis iuris. When Russia took Crimea, it occupied that territory from Ukraine because Ukraine's borders, following the rule, incorporated Crimea.
After the collapse of the Soviet Union.
Absolutely.
Yeah.
If Russia were to encounter further difficulties, and if Ukraine were to recover Crimea from Russia, nobody would accuse Ukraine of occupying Crimea from Russia. And yet we see, I would suggest, an exact parallel. Because in 1948, 1949, we have Jordan occupying East Jerusalem and the West Bank from Israel. And in 1967, we have Israel recovering that territory. And yet, the inverse occurs. Some states, very, very few, recognize Jordan's purported annexation of the territory. Most, I would suggest, called it an occupier and territory. And Jordan's conduct as occupier absolutely violated international law. It ethnically cleansed Jerusalem and the West Bank of its Jews. It desecrated synagogues, it dug up gravestones, burned Torah scrolls. But when Israel recovers that territory, the notion that it would be called an occupier is simply legally illiterate. Not least because the framework of occupation in international law developed in order to provide a framework for the administration of a territory that had been taken from a sovereign until there was some sort of resolution, usually in the form of a peace agreement. A situation of occupation has never outlived a peace agreement in the history of international law. So even if one were to completely disregard everything I have said up until this point about this fundamental rule of customary international law, and think about the relationship between Israel and Jordan, the notion that an occupation would outlive the 1994 peace agreement between Israel and Jordan is also extremely difficult to reconcile with history and legal practice, only with Israel. And this is important because I think there is a real reason. There is certainly the conduct of the state of Israel is irrelevant to the application of this default rule. Israel never had to claim the territory. Israel didn't even have to be in control of the territory in 1948 when it declared independence. The rule acts automatically as a default. And it's important that in the Declaration of Independence, there's no mention of borders. It refers to Eretz Israel. The subsequent agreements, first of all, the armistice agreements, refused to recognize any borders, But they referred back, these agreements between Israel and Jordan and Israel and Egypt, they referred back to the mandatory lines. The peace agreements between Israel and Jordan and Israel and Egypt referred back to the mandatory lines. All roads lead to Rome here, unless you're introducing political agenda into the argument. The reason that I think Israel's conduct has opened itself up to these false allegations of occupation is because of what happens in 1967. When Israel recovers East Jerusalem and the West Bank, it applies its law, administration and jurisdiction in full to East Jerusalem. It reunites the city, and it's important to note that Aviv, Foreign Minister at the time, wrote to the UN Secretary General and clarified that this was not annexation. Why? I think because you cannot annex what is already your sovereign territory. But it did not apply its law, administration and jurisdiction in full to the West Bank. It took a different approach. Under the Land for Peace framework, there was, I believe, an expectation that peace with Jordan would be secured by giving Jordan some of the West Bank that had been recovered from it in the '67 war. Ultimately, when peace with Jordan came about, that didn't happen. The Jordanians no longer wanted anything to do with that territory. But in '67, Israel instituted a temporary framework that applied certain aspects of the framework of occupation. This was the way that Israel was going to administer these territories. It did not mean it was an occupation, because that is about the underlying status of the territory, but this is how Israel decided to conduct its administration of these territories as an interim measure until there was a peace agreement. Now, ultimately, what preceded that peace agreement with Jordan were the Oslo Accords, and that changed the status of the territory by mutual agreement. The default rule is then replaced by an agreement to the contrary. And the creation of areas A, B, and C necessarily changes the legal analysis and the structure, but it absolutely didn't, because this was a matter of final status agreement, change the underlying status of the territory. So again, we come back to ultimately the position from 1948 onwards.
Well, okay, that's fascinating and really, really helpful, I think. I wanted to ask you, as you're visiting us from the UK, and we have a new government in the UK. Many people, both British and otherwise, will be familiar with the travails of the Labour Party going back to the Corbyn era, and the new leader, Keir Starmer, removed Corbyn and seemed to, at least on some level, to do a decent job of sort of clearing out some of the problematic elements from the Labour Party. Nevertheless, we're now seeing, with the new government, some troubling signs, I would say, of the direction that is going with regard to Israel, including talk of a ban on arms sales to Israel, and cancelling the previous government's decision not to acknowledge the ICC's arrest warrants, so to speak, for Netanyahu and Yoav Gallant. Can you just speak to that both as a British citizen and someone who obviously follows these things very closely from a legal perspective?
It's deeply concerning, and the two examples that you've raised, I think, give a strong indication that the legal merits, or even political merits, of the UK taking a position that is consistent with supporting the only democracy in the Middle East, or supporting the proper application of international law, are taking a backseat to what appears to be a clear political agenda, which is very anti-Israel. And one only needs to look at the tweets of the Foreign Secretary David Lammy over the last month to understand that there is something seriously wrong here. But in respect of the two issues that you have raised, under the last government, the UK made an application to make a submission to the International Criminal Court to raise its concerns on questions of jurisdiction, where the court has no jurisdiction and is making an application for arrest warrants. That's not just a problem for Israel. That's a problem for any member state of the International Criminal Court, and it struck me that the UK recognised this under the previous government and was concerned to make sure that the court stayed in its lane, that the court adhered to the parameters of the Rome Statute. The notion that there would be a complete U-turn and that this brief, this submission, which, as we understand, had been prepared in advance, would simply not be submitted, if that is contrary to the interests of the United Kingdom, that is necessarily extremely concerning if it is being done because of an anti-Israel agenda. Happily, I would say, the UK's application to submit prompted a host of other countries and also NGOs to make submissions. I'm very privileged to have been involved in UK Lawyers for Israel for 10 years now. We made a previous submission with some other NGOs in 2021 when the court was first considering the question of jurisdiction in this case. We've made a subsequent submission both on the question of jurisdiction in relation to the application for arrest warrants by Karim Khan and in relation to the accuracy of the information that he relied upon for that application for warrants. Nobody in the public has seen the actual application, but apart from going on Christian Amanpour and giving a press conference, the process, which is rather unprecedented, often these arrest warrants are asked for in secret, not to the kind of international fanfare that we have seen in this case. But apart from that, the prosecutor also put out a summary of his application, which we have been through with a fine-tooth comb, and we have, both in the submission to the court, indicated that every phrase of every sentence in that summary is false. We are working on a far larger submission to be able to supplement what has gone in, because we are very limited by the court to some 10 pages to cover both the jurisdictional questions and also the total inaccuracy of the information that was put forward. But the notion that ultimately what we're dealing with the question of the International Criminal Court is individuals. The notion that an individual's liberty might be at stake, and here we're talking specifically about Yoav Gallant and Benjamin Netanyahu, the notion that an individual's liberty might be at stake on the basis of complete and utter gross misrepresentations and inaccuracies, amongst them saying that Israel has subjected Gaza to a total siege, shutting all the borders, ultimately ignoring all of the information from Kogat about when Mount of Aviv is played in, but also, very fundamentally, the role that Gaza shares with Egypt, suggesting that there has been a policy of implementing starvation or famine in Gaza. And we've done a separate analysis of that particular allegation because we've subsequently, of course, had reports even from the UN that have indicated that the allegation of starvation or famine in Gaza is implausible. So that's a critical aspect of the problems, I think, that we've seen with the arrest warrant, which the UK was on track to make a submission about, and that in turn, I think, can only be explained by politics. In relation to the arms embargo, I fail to understand what has changed from the previous government's assessment that Israel is in compliance with international humanitarian law, that there is no issue with continuing to export arms and provide licenses for export to Israel, and today. And the really troubling aspect of this is that very early on in his time in office, David Lammy indicated he was conducting a wholesale review. He was commissioning fresh legal advice. And then we started to hear stories about licenses already having been suspended. The Daily Mail reported on this, the Jewish Chronicle reported on this, that licenses to Israel had potentially already been suspended before that review had been conducted, before the legal advice was in. Again, I think big questions as to whether or not these policy questions are being led by, as we are being asked to believe, by analysis, by legal advice, or by a deep-seated political animus towards Israel, which many people who voted for Labour in the last election hoped had passed after the Corbyn years. But I would just suggest that we judge both the party and the government on their actions, and what we have seen in no time at all is, as I say, deeply, deeply concerning.
Okay. Before we go to questions from the audience, I want to just give you the chance to plug a little UK Lawyers for Israel, because you're the director and we clearly they do very important work. You've already referred to some of it. But can you just say a little bit about what its brief is, why it exists, why there's a need for it?
I'm very privileged to serve as the legal director of our charitable trust. We have a phenomenal CEO, Jonathan Turner, who, together with Caroline Turner and a number of others, established UK Lawyers for Israel some 10 years ago as a voluntary association to seek the proper application of law to Israel, to Israelis, to combat anti-Semitism. And I'll just give a short story about one of the, I think, key early successes, which was just after the Mehdi Marmara. The intel that came into UKLFI indicated that there was another flotilla shortly after that extremely tragic incident.
This was the Turkish ship
Yes.
that came to support Gaza.
Well, it came to break the naval
Came to
blockade.
break the naval blockade, Israel's naval blockade of Gaza.
Yeah, a blockade that's recognised as lawful even by the United Nations,
Right.
which is saying something. The Israeli Navy gave multiple orders for a number of vessels in that context to stop, to dock separately, not to continue towards Gaza. And at the time, certainly the assurances were being given any aid would pass through an Israeli port and could be, after inspection, provided. The blockade wasn't to prevent aid, humanitarian provisions from going in. Blockade was to prevent weapons and other materials that might be used for terror purposes. And having not adhered to those warnings, the Israeli Navy boarded a number of these vessels. It did not anticipate meeting the level of response. The Navy SEALs, if you will, were attacked, and having come prepared for crowd control, they found themselves in a very combative situation. That was, I think, a disaster, both in terms of the military operation, but also, of course, in terms of the PR that came out of it. And so in that context, being told of another attempt to break this blockade by another set of vessels, this time coming out of the port in Athens, we, led by a number of prominent lawyers at the time, set about trying to work out what the legal approaches could be to prevent a repeat of the Mehdi Marmara disaster. And with some assistance from the local Athenian shipping lawyer, went through a series of processes, raising issues with the ship's seaworthiness, inspecting them. These were rust buckets at the end of the day that shouldn't have been considered seaworthy at all. Looking at the ship's documentation. Technical matters, perhaps, but seeking the arrest of these vessels and the prevention of them sailing out. The ultimate, sort of long story short, is that one of the issues that UKLFI raised was a relatively niche aspect of Athenian shipping law, which was to do with sailing to a point of danger. It was devised in the context of preventing vessels sailing into areas known for piracy. But the argument was, if you're sailing with the intention of breaching an entirely lawful naval blockade, that is just as illegitimate, and the Athenian port authorities ultimately agreed and prevented that departure on that basis. So that was a very early example, but since then, as a responsive organisation and as, I suppose, recognition of what UK Lawyers for Israel has been doing has grown, the number of requests that we have for assistance has exploded. Of course, in the last 10 months, it's on a completely different level. Everything from assisting students on campus to employees in the workplace if they're being discriminated against, to dealing with anti-Semitism, local authorities, BDS resolutions, in the central government in the context of the anti-BDS law that the last government was seeking to introduce, and of course everything that we're doing in the international legal context, providing a voice, arguments that Israel isn't necessarily in a position to advance, either because it doesn't recognise the jurisdiction of a court like the ICC, or the ICJ in the context of the advisory opinion that it was putting out. Making sure that those arguments are on the record. And in the context of the advisory opinion, I'll just use this example to highlight the true import of what I think that this team of lawyers is involved in. I read the dissenting opinion of Julia Sebutinde, the Vice President of the Court, and remember I said that the advisory opinion in the International Court of Justice is non-binding. It is an opinion. The advisory opinion, the dissent, is just as valid as legal analysis. I would argue far more so, because the quality of the legal analysis is far superior to what we saw from the majority opinion. But the arguments that UK lawyers for Israel and others have been raising that found their way into that dissenting opinion of Julius Ebutinde that are now on the court record, that include reference to uti possidetis juris, to the status of the territory, to everything that the court wrote roughshod over when it talked about the Palestinian territory as contiguous and just erased Israel off of the map. The fact that all of those positions are on the record in the dissent, and the fact that we saw a similar situation at the ICC in the context of the jurisdictional question in 2021, I mentioned we made similar representations. The dissenting Judge Kovacs, I think, clearly drew on a great deal of what was being put forward in that respect. Civil society has a clear and significant role to play. And in the context where so much of the Academy on International Law has been hijacked by what I can only describe as a clear anti-Israel agenda, having voices, bodies out there to advance real arguments of international law, and to include them at the very least, in the considerations of the courts in these cases, and then to see them actually adopted by at least some of the judges listening to these, having to determine these matters, is hugely significant. I consider it to be another front of this war, because as much as everything that is going on the ground in terms of the military battles that we're facing is the forefront of what is ultimately a war for survival, an existential war, our ability to conduct those military campaigns is necessarily impacted by the international debate and by the legal debate in particular. And many people are saying that Israel is having to fight this war with both hands tied behind its back. That is in no small part due to the lawfare that we have seen reaching fever pitch over the last 10 months, and from the extremely troubling rhetoric that we've heard, especially, I would suggest, from this American administration, with references, albeit they will walk back pretty soon after, to indiscriminate bombing or to breaches of international law. That's had a necessary impact on the practical ability, I think, of this country to defend itself.
Okay, Natasha, thank you very, very much. I'm going to ask Shivan, I can't see the audience.